consent.
You're watching the prosecution's closing arguments in the Frank Bybee case here on the Law News Network. The jury is currently deliberating in that case, and if they have a verdict today, we will certainly bring you the information live. In the meantime, we're going to jump into our next guest here on the Law News Network. Mychal Wilson is a Ninth Circuit attorney, and he's joining us here live on Law News to talk both about the Bybee case and the next case we have coming up here on Law News. So, Mychal, good to see you again.
Great to be back. Thank you.
So let's talk about the Bybee case here, and you tell me what you think about this. But from my perspective, the case was tried very, very well on both sides, and that's important because in some of these cases I sit and oftentimes I'm skewered for saying it, but I'll turn around and say, wait a minute, one of the attorneys was totally outmatched, and I start to have concerns about the process. In this case, I think the defense attorney made some great points in closing and really countered a lot of the prosecution's theory. And so the jury's got a lot to think about here, especially with that top charge, the attempted murder charge.
Right, and I totally agree with you. I think both sides were really respectful, especially during the defense. And the defense attorney was very smart because he pointed out, hey, I'm going to bring out some things here to prove my client's case, and I'm not being disrespectful. The prosecution's done a great job, and I respect that. And he also does the same with regards to the victim, because he was very respectful of her, saying, look, she's 80 years old, and I'm not trying to criticize her demeanor, but I have to represent my client, and that's what I'm going to do.
No, I agree. And it goes back to this thing that I was taught in law school, and perhaps someone taught you similarly in trial advocacy. But my trial advocacy professor kept saying this phrase, and it sticks in my head, and I repeat it here on Law News, and I probably should call her up and tell her that I quote her frequently. But she said, when you're whatever side you're on in court, you always have to wear the white hat. You always have to be the good guy in pursuit of either truth or justice or something like that. Now, of all the cases we've covered here on Law News, I think in this case, this particular defense attorney did the best job of that. There have been a couple of other cases where I've seen it done well. One was the death penalty retrial we covered in Las Vegas recently, the Valerio case. I thought the defense attorney there did a good job of coming across as a sympathetic defense attorney. But defense attorneys aren't there to try to get people off the hook. They're there to try to prevent the state from mischaracterizing the facts. And I think that's exactly what happened.
Yeah, I'm sorry. And especially when you have an attempted murder charge at issue right here, in which I believe, I think the attempted murder charge is hard to prove, and that's because of the legal burden. You're talking about beyond a reasonable doubt. The forgery and the checks and the fraud and all that, I think that's a standard that I think the prosecution can meet that burden. And I think, they can find him guilty on that. But the attempted murder charge is a really, really hard one because both sides have really good a dispute of the facts here. Yeah. And so when you're playing to the jury, it's got to be like basically, as almost 99.9% positive, sure that, hey, he attempted to murder her.
Yeah, exactly. There's a he said, she said in this case on the top charge. I mean, it's possible that as the jury deliberates right now, they've turned around and said, okay, the computer issues, the computer fraud or whatever Florida's version of that is, yeah, we can get them on computer crimes because we believe the evidence from the ISPs that her email address or her computer accounts were accessed from somewhere outside her home and that he had the ability to do this. So they might just turn around and check guilty on all those boxes in less than 5 minutes. They could also turn around and in essence do the same thing. Hey, look, we know money transferred hands here. We've got $65,000 in dispute. We've got $2,000 checks that have been thrown up in front of us. It's pretty clear that money moved from point A to point B. They could look at that and say, we just don't really feel comfortable with sworn law enforcement officers cozying up to people, even if it's with good intentions, and then walking away with this kind of money. If he wants to get into elder care, he either needs to incorporate a business and do it legitimately and hope that it passes some internal ethics review. There's things you and I can't do ethically because we take an oath to do one job and we can't be doing the other.
Right. And I think for the police officer for himself, I think he should have, he's held to a higher standard. There's a trust between police and the community. And elder abuse and elder fraud is a major, there's a lot of victims in our society. And I think here the officer should have stepped away from taking any money, but he didn't do that. And I think what he should have done, if he really wanted to get paid, is, like you said, incorporate, form a business entity, form your own private security firm, and then that will legitimize the payments that supposedly he received from her, and that he did not allegedly, forge the checks himself.
Yeah, it reminds me of a case in another state, and I've been trying to look the information up on it, where there was a similar accusation that an officer was sort of preying on someone. I think the facts were different. It was something was actually left for the officer in an elderly person's will,
Right.
if I'm remembering it properly. And look, I've been trying to look the facts up on it all day today. It happened a couple of years ago. But the high court got a look at it in that state and just said, no, 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 no. Police officers don't do this. They don't just go check up on elderly people frequently and then hope they get some kickback out of the will later. Like, we're just
Right.
not even going to allow this to happen. And, so it may be that the jury is sitting there in Florida saying, okay, computer crimes, we got an issue with that. We have an issue with the preying on the elderly. We'll go guilty on that. If I were to venture a guess, the argument, and I agree with you, Mychal, is going to all be over, or almost entirely going to be over, this attempted murder thing. Because, as the defense pointed out, some of the facts just don't match up. If we're to
Right.
believe the neighbor claims that this elderly victim had, and we don't know all the context of it, but had threatened to harm herself in the past. And, the neighbor claims that this woman wasn't in any kind of bad shape when the neighbor came running over hearing of an attack. And then
Right.
yet later we've got these photos of her bruised and bloodied and this, that, and the other thing. So, how did the whole thing happen?
And just to interrupt you for a second, in regarding those photographs, and that's very key, because the issue here to me was, you have an 80-year-old woman, and if someone wanted to kill an 80-year-old woman, and he's a police officer, I don't know what it was, in his 40s or something like that, I mean, she would have more than just bruises and scratches like that. And that's one of the pieces of evidence where I was like, well, I don't know if that attempted murder charge will stick, because an 80-year-old woman against a strong young police officer, there would be more physical damage to to that woman.
Well, now that's exactly what the defense argued, but I guess the flip side of it could be that maybe there wouldn't be as much damage because the woman wouldn't have the ability to fight back as harshly. So, it's not like if somebody attacked you or me on the streets where, we're able to fight back a little bit more based.
True.
I can't tell how old you are, but despite my gray hair, I'm 37.
Well, you're still wet behind the ears, because I'm older than you. So.
Oh, okay. Well, you have darker hair than me, so no one would know. But and the bottom line is that maybe she wouldn't be able to put up as much of a fight. So maybe there wouldn't
Right.
be as. I mean, evidence of bruising or injury is the result of struggle, of tension. So
Right.
I don't know if the prosecution really made that point as well as perhaps the prosecution could have.
Yeah, but one thing about prosecutors, these prosecutors, they work with cops all the time. So actually, to go the distance and prosecute a police officer, I mean, the prosecution felt very, very confident that they could meet its legal burden here. And I think one of the things at issue here too is, she's an 80-year-old woman, and some of her testimony I disregarded because of potentially, mental health issues, the mental incapacity. She couldn't remember. Well, that's normal for an 80-year-old who may not remember this, or, who to make statements like, oh yeah, I remember that person, but I can't really recognize them. I mean, that's common. And so, I kind of, the defense attacked her, trying to, make her, attacking her credibility, as a witness. And I think they did a good job, but still, in the end of the day, it's a jury. Juries have moms and dads, and they have grandparents, and they know how 80-year-old people may or may not think, and in terms of remembering facts. So again, I think the attempted murder is really hard, but I think the other charges, it's a breeze. I think they should definitely get a conviction on those.
Yeah, I agree with you, and I was pondering aloud here myself at LawNewz what's going on with this department right now. And I realize it's a relatively large county. There probably are loyalties and fiefdoms within
Right.
it. Like any organization, people are better friends with others and whatnot. But, some of these officers were called by the defense, some were called by the state. One just has to wonder what's going on as far as who's on who else's side, if
Yeah.
one can even put it that way. Does everyone in that department believe that this particular defendant should be prosecuted? I have to
Right.
wonder.
Yeah, and you're completely dead on spot on with that because there is the fraternity portion, the fraternal portion of the police department. So there is a camaraderie amongst them. Who's going to be on his bandwagon? Who's going to be on the other bandwagon? And I can tell you, as a False Claims Act attorney or AKA whistleblower attorney, I think the prosecution did a really good job here, is because they did a smell test. And it's fraud in itself is like an onion. You peel the outer layers and outer layers, and you get to the core. And I think once they started to really dive and investigate, they saw the handwritings on the checks don't match. They saw the IP addresses from the computer from the computer addresses. So from the email account. So I think they did a really good job here.
I agree. I think that there's enough evidence on these lower charges to get it. And I think the prosecutor did a great job of summing up this one issue, because you have a victim who's 80 years old. The neighbor says she's a nasty person. I mean, she used some pretty harsh language to describe this victim, and she might not be a horribly sympathetic victim. It sounds like she could, if we're to believe the neighbor's story and therefore believe the defense, that she could have been not a nice old lady, but a nasty old lady, and that's again some of the way that this particular victim has been characterized. But the prosecution was really clear in saying, hey, look, you can believe that this victim has problems and still reach a guilty verdict. And I thought that was also brilliant.
Right. Yeah, true. I mean, again, anyone who's 80 years old, they may have mental health issues. I know my father had, was going through depression when he was in his 80s. Most 80-year-olds do that. We don't know. I don't know the background of her. Maybe she has early Alzheimer's or Parkinson's or something like that could lead to her being the so-called alleged nasty woman. But at the end of the day, the police officer himself had a civic duty. There was a public trust that was violated. And to take money, whether he forged the checks or not, is really, I mean, there's no justice in that. And they will come down with some type of a verdict, a guilty verdict.
Yeah, I mean, if this is a guilty verdict on that top charge, the attempted murder charge, will it be a surprise to you?
It will be, because I don't think the prosecution met its burden. Again, we're talking about beyond a reasonable doubt. So we're talking about, greater than 99%, which differs from a civil case, which is the preponderance of evidence of 51%, say 49%, more likely than not. Here, I don't think that they could prove the attempted murder charge. Because frankly, she's 80 years old. If he wanted to murder her, I think he would have done it.
Yeah, I mean, unless the jury believes that he didn't struggle with her because he didn't want to leave evidence. And the jury could bite onto this whole element of the car left running. They could believe that was done at the defendant's hands. Now, whether or not they're going to go that far, because it does require a couple of leaps, and it's like, well, there are a lot of people who said that the house didn't smell like it had fumes in it. Of course, then again, those who testified to that were the officers who arrived towards the end of the situation. But the neighbor even said, I didn't smell anything, but the car was running, and it's apparently some kind of an attached garage where fumes from the garage can easily get right into the house. So maybe they could go that far.
So,
I mean, it is possible.
Right. So if you weigh that, you're talking about an 80-year-old woman who could have easily left her car running, right? Mm-hmm. That's totally feasible. And the cop himself, if he's smart enough to tap into her emails and forge those checks and everything, then he's smart enough to be capable enough to have a premeditated plan here to actually murder her if he wanted to do it. That's what I believe.
Yeah, let's take a listen to some of the remaining prosecutors' closing arguments here in this case. Mychal will be back with you in just a second. I also want to talk about the upcoming case we have next week.
He also deleted these chats from 1210. These are chats that he has from Marcia Soul's device to his device. Marcia Soul, they're talking about unrelated topics, then all out of the blue, there's, I'm going to change my beneficiary, go into my account, take $400 as many times you want. These are the deleted chats that are not found in the chats when Marcia Soul's phone was turned over and reviewed on December 22nd. Those chats have been deleted from Marcia's Why would Marcia do that? Just that threat. But he's got it. That's planning, motive, preparation. And what Ms. Fredwood spoke about, what about after the crime has been committed? What are some things you look at intent? So some people said post-event activities. So what do you know? He knows from Carson Plank that he's going to be interviewed, because she's interviewed, because they asked Carson Plank about him. And what does he do? He damages his phone that he's been using where it doesn't work. You heard Detective Clay said when we tried to open it, we couldn't, had no power, I had to put a new screen in, and even with that, there were signs of water damage. And he coincidentally purchases a brand new cell phone on January 15th. Why do you do that? Is that a coincidence that he just happens to damage his phone? And remember in the interview with Detective Gato, hey, can you get me your phone? Oh, yeah, it's my friend's truck. And then earlier in the interview, he says, I always have my phone on me. He doesn't have that. But now the phone is damaged. Okay. Now what I'm going to do now, I'm going to kind of transition a bit. Because you got a lot of charges in front of you. And I'm going to make it very easy for you. You probably thought when you heard Judge Mason's instructions, I didn't go to Boston with all an hour of jury instructions. But I'm going to go through those instructions with you. And I'm going to group some of the crimes together. Okay. And you're going to have these to go back with you, so I'm just going to highlight some of these things. Okay. For the attempted murder, we only need to prove these three elements. That the defendant did some act intended to cause the death of Marcia's soul. That went beyond just thinking or talking about it. They went over to her house. He did it with a premeditated design to kill her. Well, when you come over unannounced, uninvited, without consent, you only need to do her harm after you've been told to say hello. The third element. The act would have resulted in the death of Marcia's soul, except someone prevented the defendant from killing Marcia's soul, or he failed to do so. He failed in this attempt. Now, right on the bottom, there's an instruction saying, if it is not an attempt to commit first-degree murder, if the defendant abandoned the attempt. Abandonment, I'll give you an example. If he went up to Marcia's soul's house and turned around before he goes in the house to try to kill her, that's an abandonment. It's not an abandonment once you start to proceed to do it. That is where he failed to do it, okay? So if he turned around before he goes into Marcia's house, he's abandoning the attempt. But in this case, he tried. He turned on her vehicle, carbon monoxide poisoning. He tried to do it. The only reason you would do it is try to kill her. The only reason. So it's not an abandonment. An abandonment, you go up to the house and turn around. That's not this facts. Okay. The second charge you got is the kidnapping. Again, this is when he has her Baker acted for nearly 2 weeks against her will. Okay? That's what this is. The kidnapping is when this defendant sends those fake emails to Dr. Lerner her doctor, remember he looks it up on his tough book, Dr. Lerner, and his information, and he sends the fake email to Dr. Lerner. He knows that she is going to be Baker acted. How does he know? He's a deputy. He did it himself, unless. So now there's what is perceived to be the second threat, which the doctor believes, because why wouldn't it? It came apparently from Marcia. The doctor had no reason. In the heading of the email, what you're going to get, it comes from Marcia Soul. So the doctor believes that. And so this deputy knows that Marcia Soul, no doubt, she's going to be Baker acted. And you heard Mr. Latham say, well, isn't it ultimately the deputy's decision? What deputy, after now at least what's believed, because they go to the screen before, say on 10/21, she attempted, and Dr. Lerner said she needs now long-term treatment. She now needs long-term treatment because there's now this new threat. And he goes, you know, I thought she liked my wife in the email. So Dr. Lerner that contacts his office, she needs to be Baker acted. The deputy's now saying she's going to kill herself tonight. They're going to do it. He knows. You know, when you have that information, a deputy is going to take her in, that she can be a threat to herself, given the information that they believe. There is no doubt in his mind that when he sends those emails, and it's verified, because she is Baker acted by the deputy. She is. And Marcia's like, oh no, I didn't send it. She is. He knows she's going to be Baker acted. And she's Baker acted for nearly 2 weeks. She spends nearly 2 weeks in a facility because of this man. Those are days out of her life that she spent in a facility solely because of him. Because had he not sent that email, she's not being Baker acted. There's no deputies responding. There are no deputies coming to her house. Had he not looked at Dr. Lerner's information and sends a fake suicide email, and by the way, then he ensures that it's going to happen because he sends it to Mary Ann Dongo, another one. That's what the kidnapping is. Okay? And what it is with the intent to commit or facilitate the commission of his overall scheme of the exploitation. Remember, she's already complaining about it. She's already complaining about it. And he knows he has just purchased this $1,080 car rotisserie, which you've seen in the pictures. And I'm going to show you the records. He's been in her bank and ATM account numerous times, and I'm going to talk about that. But he has to get rid of her, and so secretly, when you read the definition, it doesn't mean a secret. Read that definition of secret. It means the defendant intended to isolate or insulate Marcia Soul from meaningful contact or meaningful communication with the public. That's exactly what happened. She was isolated by being Baker acted. That's what secretly means. When you secretly define, you've got to look at that definition of secretly, to isolate her. She's complaining to my bosses. So he isolates her because of the exploitation, and even after that, even after he has a Baker Act, he's going into her AOL account. You have that in the records. So that's what the kidnapping charge is.
That's a little over 50 minutes.
Okay, thank you. The burglary. Now, we prove this 3 different ways, okay? He entered the structure, that's her house. At the time of entering the structure, he had the intent to commit the homicide or the battery. So he doesn't even have to kill her. Just when he touched her, put his hands on her, there's the battery, okay? So on that, he's not invited. Remember, he's not invited. You have the phone records. and he remains in the structure, or he remains in the structure without permission. Remember, Marcia says she begged him for leave, and he said, I can't. So he's remaining in the structure even without permission. So that's why I said there's two different ways there. He entered without permission. He remained without permission. He committed a battery on her, like touching her. You don't even need to kill her, but he's trying to kill her too. Okay? So that's what the burglary is. This is different than the attempted homicide, because in the attempted homicide, he doesn't have to go into someone's house like he did in this. So the element of this burglary with the battery is when he entered to commit just touching her without her consent. A burglary was just going in without her permission. That's a burglary. But on this, it's a burglary with a battery because he touched her in her house without her permission. He was also told, enter or remain, told to leave. Exploitation. Marcia sold elderly person over 60, knowingly use or endeavor to use her funds. That's going to be clear if it's not already, from the PayPal records as well as the ATM withdrawals. He did so with the intent to permanently or deprive Marcia. He's taken her money, and at the time, he stood in a position of custody. Aside from his badge, you know he's been in his house because they give the definition of what it is to assume a position of trust, and it can be anything, okay? And the relevant language is, has assumed responsibility for the use and management of the elderly person's funds or property. Remember, he's the one going out to get Connie Thomas. He's the one driving her car. He's the one checking her out of that healthcare facility, Consular Healthcare, on the 9th of December. He's the one. So he assumes the responsibility. So that's where the exploitation is, when he's taking funds and he has assumed the position of trust. Okay? And from all the factors in contact, that is clear. It should be very clear to you that he assumed that responsibility. And therefore, it's an exploitation of the elderly, and elderly, you're going to have the definition, but clearly starts with someone.
Those were more of the prosecutor's closing arguments in the Frank Bybee case out of Sarasota County, Florida. We're still waiting for a verdict in that case. The jury has had the case since earlier today. I'm still here on the line with Mychal Wilson, who is a Ninth Circuit attorney out of Santa Monica, which is nice and sunny today from the looks of things. And we're just listening to some of that clip there, Mychal, and you know, the thought dawned on me that if the jury's to reach this top charge, this attempted murder charge, maybe the jury could think this. They could look and say, okay, this defendant gets a hold of the victim's accounts and sends these emails claiming, I want to commit suicide. So the defendant's putting words in the victim's mouth. It winds up getting her committed. And if they buy that part of the state's theory, the jury could then turn around and say, well, you know, the accusation from the victim is that he tried to get me to swallow pills, and that was sort of some kind of a prolonged struggle of some fashion. And then started the car up, and I woke up and realized the car was running. I had passed out, but I woke up and then, you know, called for help, whatnot. Mm-hmm. So part of me wonders if the jury's going to reach that top charge, if they're going to convict on the top charge, could they turn around and say that he was setting this up to make it look like a suicide, and that the so-called attack, the modes of death, are the sorts of things that a lot of investigators, including himself probably, since he's a former police officer, sheriff's deputy I should say, they're the sort of causes of death that a lot of people would look at and say, oh, suicide. Swallowing pills, leaving a car running in an attached garage, sounds like a suicide, looks like a suicide.
Right.
Is it possible that the jury could go there and say, this all lines up?
I think that that's a very good point right there, and I think they could do that. My issue with it is you know, to meet that legal burden of beyond a reasonable doubt, there's a lot of too many ifs and buts in there. You know, it's not a straight line. So, you know, again, I don't know. I think the top charge, the attempted murder charge, is a hard one, and I don't know. I really don't know if the prosecution met that burden.
I have the same issue with this as well. I do agree with your analysis, Mychal. Part of me wonders, you know, maybe the jury will see it a little bit differently. You know, we don't know exactly who's saying what behind that jury room door. So I'm curious to see how this ends. It might end today. It might go into next week. But I also want to talk to you, Mychal, about this Quentin TELLIS trial that we have coming up in Mississippi. This is a case where a 28 to 29-year-old defendant, depending on which article I believe and when it was written apparently, is facing charges, murder charges, related to the death of a young woman named Jessica Chambers. She was 19 when she died. She was basically burned alive. She had burns over 98% of her body. She was airlifted to a hospital in Memphis. She died the next day. So just in a horrible case, just absolutely disgusting. And you've got this Quentin TELLIS on trial for the murder here. Now, he admitted being in some kind of a relationship with her. I don't know all the details of it. It sounds like it was a relatively new relationship at that, and admitted to being with her on the day of the attack, but that's the extent of his admissions in this case. Initial thoughts, just hearing the facts.
Well, the murder itself, I mean, is completely gruesome. You know, I believe he made her drink, allegedly made her drink lighter fluid too.
Well,
so
you know, and I'll stop
burning.
you there though, Mychal, because, you know, that's been floating around, and my understanding is that we here at LawNewz have sort of debunked that. It was an initial theory that's kind of been cast aside, so I don't want to let anybody go down that rabbit hole. But yeah, there is that allegation is floating out there, and you know, there's a lot of stuff floating around about this case that we're finding out may not be true. So I'm not blaming it on you, but I want to stop at that one there.
Okay. Well, what I will say is Mr. TELLIS is lucky that he's actually in jail right now, in custody, and he wasn't hung and burned since this is a Mississippi. You know, it was in Mississippi. You know, from my investigation was he has a long rap sheet. It was pretty much a menace to society. He was actually in jail for allegedly killing another woman, a Louisiana woman, and I think he was in the possession of her credit cards, and that's how he was caught there. I think this is a horrific crime, and I think if the police here and the investigators can really, if they conducted a thorough investigation of the crime scene, they'll find traces to Mr. TELLIS. You know, whether it's you know, DNA or, you know, things that were at his, I believe he was living with his mom at the time of the Louisiana arrest. So, you know, we'll see what happens.
Yeah, I'm really really wondering what's going to come out in this, because as oftentimes is the case when we cover cases in smaller areas, there's a rush to try to figure out what the facts are, and the national press isn't as used to dealing with local authorities. And you know, one of these things that's been tossed around almost infinitely, it seems, is this issue about whether or not she drank the lighter fluid that you brought up. My understanding is that that's been debunked. You know, there's this other thing I'll bring up as well, though, is there are a lot of people saying that she muttered his name as sort of a dying declaration, and that's part of the evidence against the defendant. But we had a local journalist here on LawNewz earlier who said no, the officers or whoever heard it thought that she was trying to say Eric or Derek, and that's initially where all the police started to look, and that over time this has been twisted into Quentin or TELLIS, which is the defendant's name. And so, you know, there are these things out there that say, oh yeah, she muttered his name as a dying declaration, which we all know under evidence law makes it in over a hearsay exception, or a hearsay objection, I should say. It is an exception to the general hearsay rule. But it sounds like from talking to this local reporter that some of those stories aren't completely true either. So I'm really interested to see what we're going to see when we have opening statements in this case, because we may hear a lot of facts that just haven't been public, and we may not hear things that have been spun around in the rumor mill, which may be untrue.
Right, and I think in terms of high-profile cases, a dying declaration, years ago, football star, the Carolina Panthers football star Ray Caruth was convicted when his wife, or I'm sorry, his girlfriend, who had a baby, Sharika Adams, was killed. She was shot, and she called 911, and her dying declaration was, "Ray did it." And he was later convicted, and I believe he may be eligible for parole or next year. And I bring this up because we don't know really what the facts are. I do know that from my investigation that he was 8 years older from her. They went to the same high school. He was in the gangs. She wasn't. She allegedly had 2 Facebook accounts. So how did they meet? Was it online? Maybe he was a predator online for social media, because you have the other woman in Louisiana who he allegedly killed as well. So, there's got to be some connection here between the two, and I think the authorities will find that out.
And I also had this sort of rambling thought earlier today here on LawNewz, and maybe you can help me explain what's going on inside my own head here for people watching, Mychal. But look, he's facing charges about this other 34-year-old woman in Louisiana, and then we've got the Jessica Chambers death. But is this going to be one of these things where one doesn't relate to the other, so the jury in Chambers, at least my guess under the general rules, isn't going to hear anything about this other case? That just doesn't come in.
Right. No, not unless you can show it's of his mode of operation or something like that. Then I think that evidence will come in. But you're right. I think the other case against the Louisiana woman would be too prejudicial for the jury. But I think certain aspects may come in. So, he also has a long rap sheet. What evidence? What point will some of those crimes be entered to as evidence?
Yeah, I have to wonder. And maybe the prosecution's got this buttoned up. Maybe the prosecution will turn around and say, "Hey, look, this is this guy's MO. He, and again, I'm speculating here, but they might have such a case where they say he's done it again and again and again, and this fits the MO." That said, if I were the defense attorney, I would object to it even coming in. But if it did come in, I'd turn around and say, "This doesn't make any sense. You've got one woman of Southeast Asian descent who's 34 years old. You've got another who's 19, who's white, blonde. They don't in any way look similar, so you can't turn around and say he has some predisposition to, hunting down women of a certain ethnicity, hair color, the sort of stuff you usually hear when you hear those connected MO theories come out of states. And I've heard it before. Oh yeah, he goes after brunettes, or goes after this type of woman. These. I think the defense could split that apart and say these things don't even sound alike. And one is and look at the type of crime. You've got one gasoline immolation basically, and you've got one that's a stabbing. So the murder weapon is completely incongruent here. I think a good defense attorney could cut that apart pretty easily.
Yeah, except for one thing I will say though, and barring any fake news that I read on the internet, I'm doing research for this. The one commonality I will say in terms of an MO is he had possession of her credit cards for the Louisiana woman, and allegedly Jessica Chambers, the night of the incident of the murder, she went to the gas station. There's a gas station video. She brought like 3 times the amount of normal gas than she usually does, which is $14. I believe she usually buys $5, increments of $5 in gas. So was there a plan there where he was trying to maybe steal credit cards from her, kidnap her maybe, so I think the police, though, I think they'll find some commonality here between these two crimes. And I also think it's important for them to really investigate the social media profile of Mr. Tellis to see if there's any connection there. He may have been a predator. Child trafficking, human trafficking in the U.S. is really huge, partially because of social media. And so, there's a lot of predators online.
Well, it's possible we could hear that argument, but I don't know for sure at this point. What I know is that we've got a horrific death here. We've got a defendant with a rap sheet. And as always, I'll sit here and look at the process and say, hey, look, is this a great trial? Do we have good lawyers? Am I comfortable with the outcome of the verdict because I'm comfortable with the process? Or am I going to sit here and say, hey, look, I'm not really sure I like the way this is going down? But that's what we do here at LawNewz. So,
Right, and I will add this one thing for you. It's going to be tough for Mr. Tellis. Black man, white, black male, white female, Mississippi. And although they did, I believe, went to a jury that was like over 200 miles away, in terms of a jury pool, it's going to be hard for him to overcome this if the prosecution has some direct links regarding Mrs. Chambers.
Well, I'm hoping that the voir dire process sort of weeds out any, and I hate to stereotype, but I hope it weeds out any issues in the jury pool.
Right.
We do have a sequestered jury. We do have a jury from 200 miles away, as opposed to what we saw in the Holly Bobo case, which is a jury from the very next county who probably
Right.
had heard everything about the case anyway. So what's the point of bringing a jury from the next county and sequestering
Right.
them? I mean, it just, 200 miles is enough of a distance where I'll turn around and look and say, well, we move cases here in New York from New York City to Albany, which is less than 200 miles, but it might as well be on the other side of the planet because there's such a
Right.
difference between upstate and downstate attitudes, sensibilities, lifestyles, whatnot. So 200 miles away in Mississippi, I'm hoping that it's enough to kind of get out of the local sense of what's going on. But then again, it's a case that's attracted national attention. I'm sure that people in Mississippi know what's going on in this case.
Right, exactly. In Mississippi, in terms of the communities there, they're very tight, small towns that are interconnected. So, again, neither the prosecution or the defense are going to get the complete jury they want. But I do think that this jury makeup will favor the prosecution.
Yeah, I mean, I'm sure that they probably will. But some of that may also be the degree of the evidence. So we'll have to wait and see. So, Mychal Wilson, we say Ninth Circuit attorney, a man with appellate experience in Santa Monica, California. Good to see you here
Supreme
again on
Court
LawNewz.
bar member as well.
Okay, well, you've got that piece of paper that I haven't sent the money in for yet, but you've given me something to do now with my next paycheck. So
There you go.
all right, Mychal Wilson, good to see you again here on LawNewz. We'll
Thank
talk
you. Have
again.
a great weekend.
Okay, you too. We're going